All rise.
Mr. Singh, we decided that it would be over-ambitious to seek to finish this substantive appeal and to deal with anonymity by close of play tomorrow. Quite apart from, we understand there have been requests for discovery in the latter.
I see.
And so we propose to finish this tomorrow and to deal with anonymity on the 22nd of October.
Thank you, Lord. My lords, my lady, I was showing the court the opinions of the House of Lords in Al Jeddah.
Yes.
Before I return to that, can I just briefly address my Lord Mance on one question he asked me about a reference. My Lord asked me about whether articles in the bundles of authorities commenting on Cardi. There's one that the parties have found to date and included in the joint bundle of authorities. That is an article by Professor Takis Tridimas of Queen Mary, London. And that, my Lord, is at volume 12, tab 93.
9-3.
9-3. I'm grateful. My Lords, my Lady, going back to Jeddah, Al Jeddah, if I may, can I take the court back to page 374, where there begins the opinion of my Lady Baroness Hale, and my Lady touched on the second argument at paragraph 125 and following on page 376, where my Lady said, I also have difficulty with the second argument. It would be so much simpler if the European Convention had contained a general provision to the effect that the rights guaranteed are qualified to the extent required or authorised by the UN resolutions. This may not be surprising. By then, the European nations who had vowed never again would tolerate abuses they had suffered before and during the Second World War had become disillusioned with the UN as a reliable source of human rights protection. And there's a quotation from Professor Simpson. Now the UN has to some extent emerged from its Cold War paralysis. Some way has to be found of reconciling our competing commitments under the UN Charter and the European Convention. I agree with Lord Bingham, for the reasons he gives, that the only way is by adopting such a qualification of the Convention rights. That is, however, as far as I would go. The right is qualified but not displaced. This is an important distinction, isn't sufficiently explored in the all-or-nothing arguments with which we were presented. We can go no further than the UN has implicitly required us to go in restoring peace and security to a troubled land. The right is qualified only to the extent required or authorised by the resolution. What remains of it thereafter must be observed. This may have both substantive and procedural consequences. And then, in the interest of time, can I invite attention to the rest of my lady's opinion? I hope I do it justice by summarising it in this way, that at least on the procedural point, as I said earlier before the short adjournment, that it did leave intact, for example, the opportunity to go before a court of law. We would submit, my lady, as required by Article 5.4, because the resolution in that case didn't, in any express way at least, seek to depart from procedural fairness in Article 4 terms. May I then turn to the opinion of Lord Carswell, which touches on the second issue at paragraph 131. Towards the end of that paragraph, his lordship said, on the second issue, the application of Article 103 of the Charter, I also agree with his reasons. I would only add a few observations of my, that's Lord Bingham's reasons, a few observations of my own. And then there's reference, as I understand it, to the argument about whether authorising measures came within the purview of the obligation in Article 103. towards the end of his opinion, Lord Carswell said at paragraph 136, I'm accordingly of the opinion that the UK may lawfully, where it is necessary for imperative reasons of security, exercise the power to in turn conferred by Resolution 1546. I would emphasise, however, that that power has to be exercised in such a way as to minimise the infringements of the detainees' rights under Article 5.1 of the Convention, in particular by adopting and operating to the fullest practical extent safeguards of the nature of those to which I've referred in paragraph 130 above. And I merely ask the Court to cross-refer to that in due course without taking time to read it now. In a somewhat fuller opinion, my Lord Brown considered this, having dealt with attributability earlier. My Lord turned to issue 2 at page 383 from paragraph 150. And I hope I do justice to my Lord's opinion if I focus particularly on paragraph 151, where my Lord said that the sound and more fundamental reason for holding the Article 5.1 proscription on internment to be qualified or displaced here is that Article 25 of the Charter requires Member States to accept and carry out Security Council decisions. And Article 103 provides that in the event of a conflict between that obligation and the Member States' obligations under any other international agreement, the former are to prevail. If I may say so, my Lord has very crisply and concisely there put the fundamental point. If that is right, then so be it. The Convention on Human Rights, and indirectly, therefore, the Human Rights Act, does not have the effect that it would otherwise have. My Lords and my Lady, we respectfully submit that if that is truly the effect of the relationship between Al-Jeddah and international law, then it would, with respect, lead to some very unpalatable consequences. And I preface what I'm about to say by reminding the Court of where I began this particular submission, that although, as a matter of fact, Al-Jeddah concerns occupied Iraq, as a matter of legal reasoning, I hope I say this fairly, that nothing in what I've shown the Court so far turns upon that fact. My Lords and my Lady, we also know from the facts of the present cases that listing people by name in UN Security Council resolutions is a technique which is now used by the Security Council. We've seen that in my client's case and Mr. Hay. My client, as I've said many times now, is a British citizen living in this country. Now, my Lords and my Lady, I hope it's not an interiorum argument if one simply tries, as it were, to test how far the legal reasoning in Al-Jeddah can really go if one just postulates the following scenarios to test the legal principle. I accept they may be extreme, but not necessarily, I would suggest, fanciful. Suppose that instead of asking member states of the UN to freeze my client's assets, the UN Security Council also named him and said he is to be interned. Now, as I understand it, the logic of a combination of the legal reasoning in Al-Jeddah and Mr. Swift's argument would be that Article 5.1 and the Human Rights Act would not avail an applicant in that situation because the international obligation and the Charter would have qualified or arguably displaced Article 5.1, at least to that extent. And the fact that there can be detention without trial on the soil of this country in recent times in response to 9/11, of course, is illustrated by what happened in the Belmarsh case. And it's even more unnerving, if I may say so, because your lordships and ladyship recall that it was the UK government that asked the Security Council to put my client on the UN list. One hopes that they would never take this further step. But just to test the legal analysis, suppose they did take the further step and ask him to be put on a list of those the UN requires to be interned. The legal effect of the reasoning in Al-Jeddah would be, as I understand it, that even without the need for derogation under Article 15 of the European Convention, the UK government would have succeeded in achieving internment of British citizens on British soil and would not have to, A, justify that under Article 5, 1, or B, even have to show that there was such a national emergency threatening the life of the nation that the terms of Article 15 were satisfied. Because what it could say, consistent with the reasoning in Al-Jeddah, is that the UN has spoken, we have to comply with that obligation, and it overrides our human rights treaty obligations. Now, my lords and my lady, if that is the legal consequence of the reasoning in then of course we must accept that. Unless and until the Court of Human Rights revisits the question, as it may, can I just inform the Court that, so far as I'm aware, there's no hearing yet listed in Strasbourg, but Al-Jeddah has been held to be admissible and is to be heard by the Court of Human Rights. By Grand Chamber. Mr. Hussein tells me by Grand Chamber.
Going straight to the Grand Chamber?
Yes. My lords and my lady, I'm sorry. It's hazardous to guess. My feeling as an advocate is that it's likely to be in the new year, but I don't have any more concrete information than that, my lord. It's simply going by experience of how long it tends to take to list. My lords and my lady, the point, and again, I stress that I'm not giving this example because it's either one that is likely to occur in practice or one hopes would ever occur in practice. But I hope I'll be forgiven at least for testing the legal analysis by reference to this scenario. Suppose you had a situation, and it's the kind of situation that Lord Shaw of Dunfermline refers to in that old case of Halliday that I invited attention to this morning. Suppose you had a situation where there is a war or some emergency going on, and the UN route is taken at the international level of having a list of people on whom the death penalty should be visited. It may even be after a trial. Now, my lords and my lady, the situation under the European Convention, so far as the UK is concerned, because it is now ratified and incorporated in the Human Rights Act, the 13th Protocol, which replaced the 6th Protocol, is that even in time of war or emergency, the 13th Protocol prohibits the death penalty in all circumstances whatsoever. The 6th Protocol used to allow it in residual cases. The 13th Protocol does not. That is a domestic law right, because it's in Schedule 1 to the Human Rights Act. And suppose, to make the scenario perhaps a little more realistic, it was not that the state itself should impose the death penalty, but that at the least it should depart from its obligations in serving and should be prepared to hand over by extradition a person, a named individual, because that would be similar to our scenario. Let's suppose that the person concerned, a British citizen, must be handed over to face a trial where the death penalty may be imposed in the United States or a similar country. On the face of it, the obligations in the European Convention, the 13th Protocol in particular, would prevent the state from doing that. if we've understood the reasoning in Al-Jeddah correctly, and if it really is to be said that the UN obligations override even that right, then in my respectful submission, that would be a most surprising consequence. And my lords and my lady, it's important that I give that example rather than a torture example for this reason, that it is widely recognized that the prohibition around the world on torture is a norm of the jus cogens. The prohibition on the death penalty, while it's subscribed to by many states, including European states, is not, on current understanding of international law, a norm of the jus cogens, because many democratic states, and certainly other states, still retain it. And so, in my respectful submission, it's another way of testing whether the legal reasoning in Al-Jeddah on analysis can actually be right. Justice, and we endorse their submission about this, suggest an alternative way of reconciling human rights norms with international obligations to the UN. And that's really the last topic I want to turn to on this ground of appeal. And that's by showing the court the case of Bosphorus in Strasbourg. You've seen it in Luxembourg, but subsequently it went to Strasbourg, and that's in volume 16, that's tab 130. My lords and my lady, the material part of the court's judgment is to be found from paragraph 150 on page 44 of the report. And it's actually quite a long passage, which goes from paragraph 150 over the next 4 pages to paragraph 167, where they find in the end no violation of Article 1 of Protocol number 1, the right to property, because in the circumstances there was a justified interference with that right. Time does not permit me to go through this at great length. I do invite attention to the whole of that passage. Can I summarise it in this way, as Mr. Fordham has eloquently done in his written case, that what one derives from this passage is that there is a principle of equivalence in Strasbourg. And by equivalence, we mean that the Court of Human Rights does not simply give up the exercise of adjudicating itself under the Convention, where what a state relies upon is legal obligations, let's say, to another international organisation. In that case, it happens to be European Community law, but it could equally be the UN. Rather, what it does is that it pays due respect to the fact that the need for international cooperation is obvious in our modern world. There are many good reasons why nations cooperate to combat a number of social ills and so on. So it recognises and gives due respect to that legitimate aim of public policy. But it also asks itself, in striking a balance under the Convention, whether there are equivalent human rights guarantees in the legal order of the organisation concerned. And there, even then it's not an irrebuttable presumption, it refers it to paragraph 156 to a rebuttable presumption that where there are such equivalent protections for human rights in the other organisation concerned, there's a rebuttable presumption that the state is not acting in breach of its convention obligations. But nevertheless, it's entitled to and does adjudicate on the issue.
Is this something that's used in the extradition context?
I'm not aware that the same analysis has been done, my lord. That may be because, unlike this right, the sort of rights that Söring, for example, concerned were absolute rights, and so the balancing wasn't done.
It's the same exercise that the German Constitutional Court undertakes in the Solanger decisions, in relation to the European community.
I see. Lord, I'm
So
great.
long as
I see,
it
yes, yeah.
acts in a way which is consistent
I see.
with the German, broadly consistent, then
Yes, exactly.
we will trust it and accept it.
Exactly. Lord, I'm grateful for that. I wasn't aware of that myself, but I'm grateful. It's another way we respectfully submit to this court of trying to... everyone acknowledges this is a difficult area. There are tensions, but in our respectful submission, it's a preferable way of trying to achieve legal harmony in this difficult area, rather than to take a more absolute approach, as I understand it to be, the legal reasoning in Al-Jeddah would support, which is that to the extent of an inconsistency between the ECHR and the UN obligation, you can simply give effect to the UN obligation without further consideration. My lords and my lady, before I... I'm sorry. Yes. My lord, I'm grateful.
It's 157. There's a reference to the Matthews case.
Oh, yes.
Okay. And it says it can be distinguished. The acts for which the United Kingdom is found responsible were international.
No, I don't. I have to confess, I'm vaguely aware of the Matthews case, if I've got the right Matthews case, but I'm afraid on my feet, I can't offer more assistance than that. If we can help, then we will overnight, perhaps, if we may. Yes. There is that additional, I would say, unnerving feature of the present case, but of course, it may not be, and I don't want to cut across anything Mr. Hussain may want to say. We would both submit to the court that the fundamental legal principles are the same in both of our cases, although I have that disturbing factual feature about my case. My lords, my lady, what I wanted to say just before leaving this second round of appeal is that, of course, my primary submission is based on the common law, and your lordships and ladyship don't have to address the Al-Jeddah difficulty, if it is a difficulty, if our primary submission is accepted. But if I'm wrong about that, then we, with due respect, invite reconsideration of Al-Jeddah.
I think the Matthews case, the point is that the United Kingdom had entered into the European community and reached agreements which I think purported to deprive the inhabitants of Gibraltar of a vote.
Yes.
And that was held to be contrary to the European Convention on Human Rights, and we duly gave the Gibraltarians a vote in the southwest of England, and Spain then took us to the Luxembourg court on the grounds that we were in breach of the European community legal order, but I think the court disposed of that one.
I see. Yes, I recall the Strasbourg judgment about the Gibraltar voting rights. Yes,
but I think it worked out the right way round.
Yes, I'm grateful.
Yes.
Very briefly, may I turn to our third ground of appeal. This relates to certain procedural deficiencies. We've developed this at paragraphs 41 to 50 of our printed case, and I'm going to just take that as read. Can I also say that we adopt, without further elaboration, what is said by my learned friends in Mr. Owen's case. In their printed case, these procedural deficiencies are dealt with at paragraphs 45, forgive me, pages 45 to 60 of their printed case. And essentially, they boil down to this, that whatever may be said by Mr. Swift in relation to Mr. Owen, where there have been certain legislative amendments made to the terrorism order regime, so, for example, special advocates can now be appointed under a statute. REPA has been expressly amended. I'll show you, lordships and ladyship, that in a moment. But just to explain where we are in the analysis this point only arises, and it's not academic on any view in our case, in this narrow scenario, that if I'm wrong about what I've said so far, but the Court of Appeal was right. So I'm wrong, Mr. Swift is wrong. The Court of Appeal's middle way is the right way, because the Court of Appeal said that there is an opportunity for some limited judicial review, and we've made our submissions why that doesn't work. But nevertheless, if that is the outcome of this case, then we have these additional submissions to make. It's not academic in our case, because as I'll show the court in a moment, the statutory amendments made by the Counter-Terrorism Act 2008 would not touch upon that limited kind of judicial review at all. To make that good, can I show the court that act? It's volume 18, tab 148.
I thought this was uncontentious. Or is it contentious?
Well, I don't think it's contentious that the legislative amendments don't touch our sort of
Exactly.
case. I think what is contentious is it's said by Mr. Swift that it's academic, even in my case. If I've misunderstood that, I'll sit down, but I thought it was still being said that even in my case, it's academic.
Academic.
It doesn't arise. I'm going to take no more than 5 minutes
Yeah.
of the court's time, just to show the court the relevant statutory provisions, to show what the problem is. And I can make it good by reference to two pieces of legislation only. First, the 2008 Act, behind tab 148. Section 63, in a part now headed Financial Restrictions Proceedings, provides that this section applies to any decision of the Treasury in connection with the exercise of any of their functions under the UN terrorism orders. And then subsection 2 provides that any person affected by the decision may apply to the High Court to set aside the decision. So that, in a sense, replaces Article 5.4 of the terrorism order. There never was such a provision in the Al-Qaeda order, and in my respectful submission, it still doesn't help someone in my position because there is no decision of the Treasury. That's the whole point Mr. Swift makes against me. And then, although the Al-Qaeda order is referred to as a UN terrorism order at section 64(1)(d), so it's part of the interpretation section there, that can only be a reference to that part of the order, the court will recall, which did confer a power on the Treasury to make a direction, even under the Al-Qaeda order. So the part of it which simply says you are Osama bin Laden, or you are Mr. G, and you're on the list, still, in my submission, doesn't fall within this definition.
As a matter of interest, I mean, why, if it's on the list, why would the Treasury ever then need to make a direction, or want to make a direction?
Oh, yeah. That may be, I don't know, that may be better directed to my learned friends, but
Well, there are cases, aren't there? I mean, one of them is where they're not sure
exactly.
where the person doesn't admit that he's the
Exactly.
person, and the Treasury then says, Mr. Smith is, we reasonably suspect,
yes.
Yes. I see. If there's some doubt whether it's the right chap.
Yeah, it says reasonable suspicion that you are the person on the list, triggers the power. This is Article 4, the conditions in Article 4.2 of making a direction include the scenario. For example, if Rabinder Singh is not the advocate in this country, but is apparently the former CIA agent who is on the run, I'm told, if you Google the name. And that may explain why I often get stopped at airports. But there it is. Now, if the Treasury think, not sure, but they have reasonable grounds to suspect, then they can make a direction. My lords and my lady, section 65 of this Act says that in this chapter, financial restrictions proceedings means proceedings in the High Court on an application under section 63. And that's important because there's a number of more detailed provisions which are then to be found in this new Act, governing such things as the appointment of a special advocate, see Section 68, and very importantly, intercept evidence, see Section 69. And your lordships and ladyship will see that REPA is expressly amended to refer to financial restrictions proceedings as defined in this CTA. Now, Mr. Justice Collins dealt with these procedural problems on the law as they then stood in his judgment at paragraphs 41 and 47. I don't go to that now, but I simply give those references, and the court will understand that the significance, he is an experienced judge in the field of SIAC, having chaired it, and so on, took the view that in his experience it was almost invariable that you were going to need to have a fair hearing, you were going to need a special advocate appointed, and importantly, there was going to be intercept evidence in issue, exculpatory or inculpatory, or at least in the background. Now, the special advocate's problem might, it may be said, conceivably be dealt with on a case-by-case basis, because it will be said by Mr. Swift that Roberts in the House of Lords holds that there is an inherent jurisdiction to appoint a special advocate. We don't accept that, nor does Mr. Owen, and the submissions have been made in full in writing. But even if that were right, there is a fundamental problem in relation to REPA and the prohibition in statute of the reference to intercept, even the fact of an intercept. And can I show the court the reference to REPA, which is in volume 17 at tab 138. This is the version as amended by the 2008 Act, so it's helpful to see it as it now stands. First, Section 17 is the exclusionary provision. Subject to Section 18, no evidence shall be adduced, question asked, assertion or disclosure made, or other thing done in, for the purposes of or in connection with any legal proceedings, which in any manner discloses in circumstances from which its origin in anything falling within subsection 2 may be inferred, any of the contents of an intercepted communication or any related communications data, or tends to suggest that anything falling within subsection 2 has or may have occurred or be going to occur. And then examples are given in subsection 2, in particular paragraph C, the issue of an interception warrant. In other words, the fact of that, not the content, but the fact of it. Or D, even the making of an application by any person for an interception warrant can't be referred to. Then, of course, as one would expect, Parliament has set out specific exceptions to that general rule in Section 18. And these have, from time to time, been amended. And one can see the most recent amendments in the 2008 Act in subsection 1, paragraph DB, any financial restrictions proceedings as defined in Section 65 of the CTA. And if that exception then applies, then some consequences follow from subsection 2. I'm not entirely sure why this paragraph system has been used, but it's called ZB. In the case of proceedings falling within paragraph DB, there can be disclosure to a person other than Treasury who is or was a party to the proceedings, or any person who, for the purposes of the proceedings, but otherwise than by virtue of appointment as a special advocate, represents a person falling within. In other words, it's a negative. So those people can't be given the information, but there are those limited exemptions, the Treasury and the Special Advocate. Now, the fundamental problem, if the Court of Appeal is right, and both sides, as it were, in this court are wrong, is that none of this says anything about the sort of judicial review proceedings that the Court of Appeal envisaged could take place, and indeed have taken place in Mr. Hussein's case. And the fundamental point Mr. Justice Collins was making, we respectfully recommend to this court, in disagreement with the majority of the Court of Appeal, and we submit simply that Mr. Justice Collins was right, that you can't have a fair procedure. Suppose, for example, there was exculpatory material from intercept evidence, and it simply couldn't even be known to the judge.
Is that example really your only point on intercept evidence? Because in other situations, one needs the intercept evidence to be examined by a special advocate, because otherwise it's being relied upon. But unless it's there's some process by which it can be relied upon, you're not going to be prejudiced unless it's exculpatory.
Certainly for my purposes, my Lord, I would say, I wouldn't necessarily want to say exclusively it's the only, but I would certainly accept it's the best example. And I'd say it's the only example I need to illustrate the potential unfairness of a system which doesn't allow for that. And in the absence of amendment by primary legislation, which there has not been, we submit that Mr. Justice Collins was right.
Is your paragraph 47 in your case correctly formulated?
Yeah, just check.
Particularly the second sentence. Is that right?
Well, that's the premise of your whole argument.
Yes, that we had.
Yeah.
Yes, I hope.
I thought, but as I may have got it wrong. As I see it, you couldn't disclose to a special advocate or to anyone who was a party to the proceedings the material. That's the effect of well, even where DB applies.
Yes.
DB doesn't apply at all, you say.
Exactly.
But if DB does apply, that's not the reason, the non-applicability of DB is not the reason, is not a reason why the judge couldn't disclose to himself, because there's a separate provision, section 18, subsection 7, which seems to be general, enables any judge to disclose such material to himself. So the real problem is that he could disclose it to himself, but he couldn't disclose it to a special advocate.
My Lord, that may be right, and for the sake of the argument, I'm certainly prepared to accept that. But your Lordship still has the point.
Yes, I've got the basic point. I just wondered whether this was a bit broad.
Lord, can I put it this way? That we stand by what we've said, but even if it's wrong, the underlying point about unfairness is still, I hope, a good one.
Right.
My Lords, my Lady, may I just take a moment? I'm grateful to the Court for its patience. If I can assist further, of course, I will.
No, thank you very much. Mr. Herman? Yes, Mr. Hussain.
My Lords, my Lady, I am in the happy position of being able to adopt all of Mr. Rabinder Singh's submissions, but in the less fortunate position of having to follow him. My Lords, my Lady, unlike Mr. Singh's client, my client is not subject to the terrorism order. As regards the issues that arise in this case, there is obviously the contest between Mr. Swift and I on his appeal, and there is my cross-appeal on remedy. But we also, with the court's leave, seek to avail ourselves of the benefit of any positive ruling by the court in our favour on the human rights issue, the Al-Jeddah point, as it were, on which we reserved expressly our position before Mr. Justice Owen, and on the issues of legal certainty and proportionality, which have been principally advanced by Mr. Owen on behalf of his client. My Lords, my submission on the Treasury's appeal essentially are twofold. Firstly, we say that the Al-Qaeda order is ultra vires, Section 1 of the 1946 Act, because it violates, in the starkest possible form, my client's constitutional right of access to the court, because the court cannot deliver an effective remedy. The focus in this case is on the question of remedy rather than due process, for reasons which the court will see in a moment. The Treasury, in its printed case, seems to consider that the constitutional right is all about access and very little about the court. We resist such an austere conception of the constitutional right. We say it is inimical to the rule of law. My Lords, my Lady, our second point is that even if the Al-Qaeda order is not generally ultra vires, the enabling provision, because access to the court can be secured in the way contemplated by the Court of Appeal, with it being sufficient by way of remedy that the Treasury or the Foreign Office can be required to move the Sanctions Committee in New York following a successful merits review, then we say the application of the Al-Qaeda order is unlawful in my client's case. That is because we say, with respect, my client is distinguishable from Mr. Rabinder Singh's client, because first of all, the UK isn't the nominating state, and secondly, it is plain now that the UK's efforts at delisting my client since June of this year, as we now know it to be, have proved unsuccessful. And the court may be interested to know that my client was on the, quote unquote, agenda of the Sanctions Committee 2 days ago on this Monday. And we'll come to that in a moment, my Lords and my Lady. So what we have called in our printed case the de facto analogue of an effective remedy, we say that is what effectively the Court of Appeal, with respect to them, contemplated, with the executive being required to move the Sanctions Committee, simply hasn't worked in our case. My Lords, my Lady, may I please hand up a letter which I would like to take my Lords, my Lady, to, which my instructing solicitors received last Thursday. This is a letter from the sanctions team in the Foreign and Commonwealth Office to Mr. Miller. Thank you. And we say that this gives an indication of the kind of body that the committee is. As a committee of the Security Council, it indeed appears to be a committee, Mr. Smith said, in which there is negotiation and discussion, and the language is illuminating. I invite my Lord, my Lady, to read the letter. So the first point we make is that we were told about this development in response to our printed case. Nobody saw fit, I hope this is a fair point to make, nobody saw fit to tell us before receipt of our printed case that a request had actually been made on the day that it was made. It appears from this letter that a request was made on the 26th of June. Neither we nor Mr. Justice Owen were told about that. The hearing before Mr. Justice Owen was on the 1st of July. We were told that it had been decided to support delisting and that it was no longer appropriate for Hay to remain on subject to the Al-Qaeda order. We weren't told that a request had been made. We weren't even told in the Treasury skeleton, which was drafted 3 days after the request had been made, that the request had been made. And we simply say, and I hope it is appropriate for me to say this, that it is unacceptable for this lack of openness to infect proceedings in the domestic courts. It appears from the letter that over a week between the 7th and 14th of July, a number of states were not in a position to accede to the UK's request. We don't know if they were neutral or if they positively objected. The engagement continues, and there will only be a final decision when there is unanimity, with the possibilities my Lord Phillips noted of referral to the Security Council itself. Those instructing me have asked as to the outcome of the meeting on Monday, and they were told that nothing of substance occurred and that he will be on another agenda at another time. My lords, my lady, if this is what the Court of Appeal envisaged by way of an effective remedy, then we respectfully say that it was wrong to do so. My lords, my lady, the Treasury submit in their printed case that Mr. Justice Owen made a number of factual errors in arriving at the conclusion he did. That's the first thing they say. They say essentially that contrary to his understanding, the UK did have all the information upon which the Sanctions Committee acted. They say that Mr. Justice Owen ought to have considered the possibility of an appointment of a special advocate in proceedings before him, and that my client is effectively in the same position as G as regards the UK moving the Sanctions Committee. Our objections to those submissions, which I wasn't intending to take time over, I can, if the court wishes, are set out in our printed case. We say in summary that it isn't appropriate for the Treasury to take those points jurisdictionally because of the nature of this court's jurisdiction on a point of law of public importance. We also say, with regret, that it's not appropriate for the Treasury to take these points given their conduct before Mr. Justice Owen and the patent lack of candour, as we put it, displayed before him. The general objections are set out at paragraphs 44 to 45 of our printed case, where we take the jurisdictional objection and the objection derived from conduct. And then on the first point about the UK having all the information, our submissions there are set out at 46 to 48. No hint of this whatsoever was given to Mr. Justice Owen, and the contrary.
These matters don't go to the root of your case at all.
They don't, and I wasn't going to take time over them. But essentially, the contrary impression was given very clearly in both the witness evidence served from Mr. Roberts and in Mr. Swift's skeleton argument, we respectfully submit. We deal with special advocates at 49 to 51. Again, no suggestion whatsoever that special advocates were being invited. And on the last point, that Mr. Justice Owen erred in refusing to consider or declining to consider that Hay was in the same position as G at 52 to 60. So the position is, my lords, my lady, we still don't know who nominated my client. We were told by way of receipt of the Treasury's amended grounds of resistance in the judicial review proceedings that this quite dramatic volte-face had been effected and that it was no longer appropriate in the Treasury's consideration for my client to be listed. Do you get that from the amended grounds at paragraph 31? That's the first time that my client is told that it's not appropriate to delist him.
Sorry, where's that?
It's paragraph 31 at page 76 of the appendix.
That was on the redating of the 19th of June, is that right?
This was served on the 22nd of June, but it's, yes, it's on,
It's underlined.
the document is drafted or redrafted on the 19th of June.
I'm not sure I've really got this. Before that, the position was what?
My Lord, the position before that was since December, well, I should perhaps very quickly begin at the beginning. Hay was listed by the Sanctions Committee on the 29th of September of 2005. On the 10th of October 2005, the Bank of England issued a press release advising financial institutions they shouldn't handle his assets and should freeze them and so forth. In December of 2005, having waited approximately 2 months to receive a legal license, my instructing solicitors asked for disclosure essentially of two things. First of all, the identity of the nominating state. Secondly, the material upon which the Sanctions Committee had proceeded. Those efforts were entirely fruitless over a 3-year period. The only thing that was disclosed in September 2008 was an Interpol red notice, which didn't have any information at all in it as to the connection between my client and Al-Qaeda. It was simply contains generalized allegations as to his alleged criminal involvement. That's all that he received. Judicial review proceedings were brought in February of this year, asking for a merits-based review as contemplated by the Court of Appeal, and in the alternative, saying that if he couldn't have that, seeking a quashing order in respect of the Al-Qaeda order itself, or at least insofar as it applied to him, given the way the Court of Appeal had appeared to fashion a remedy. Mr. Justice Collins granted permission in April of this year at a contested inter partes hearing. And then we receive the amended grounds of resistance on the 22nd of June, and that is a document which I've shown you. It begins at page 67, and the relevant passage in the penultimate paragraph of the document is this rather dramatic volte-face, as I described it.
In your favour?
I hesitate to rise, but there is one rather important matter that Mr. Hussain has forgotten from that history, and that is that at the turn of the year, the Foreign Secretary informed HAY that he would be undertaking a review of the matters that he knew relating to HAY with a view to determining whether or not the United Kingdom would or would not support an application for delisting to the 1267 committee. So the suggestion that the pleading, which was accompanied by a witness statement which explained the position, was out of the blue, is perhaps a little out of context. I apologise for writing.
Is your witness statement in the appendix?
My lord, it is, yes.
I was going to take... I'm going to take the court to it. It's at page 304. This is the witness statement from Mr. Roberts.
Yes.
304 is the relevant... The evidence as to the review begins at page 302. The critical passage is at paragraph 36 at 304. But you'll see this is also dated 19th of June of this year.
Yes, I noticed 3. The FCO was going to act at the appropriate time in this overall review process, which was dealing with all the...
Yes, my client was in the second tranche of those that fell for review. My Lord, then the hearing before Mr. Justice Owen takes place on the 1st of July, and he makes his order on the 10th of July that the application of the Al-Qaeda order to my client is unlawful. The first, we are told that a request had actually been made to the Sanctions Committee following that change of position by the Treasury on the 19th of June, or at least it was communicated to us on the 22nd, but the documents drafted on the 19th. The first we're told is in the printed case served by the Treasury at paragraph 46, and the first time we're told about the date on which the request was made is in the letter to which I took my Lord's, my lady. And my Lords and my lady, the difficulties under which my client and my family have been, my client's family have been labouring are set out in a witness statement in the bundle at page 125 onwards. I won't take time over that. Safe to say that that my client is a disabled person. His wife suffers from considerable mental health problems, and those of the court who heard the M case will no doubt recall the kinds of problems which this family have encountered, with currently no prospect of termination. My Lords, my lady, that brings me on to the heart of the appeal and the key legal issue in this case, namely the concept of the constitutional right of access to court and the concept of an effective remedy. We say that for a remedy to be effective, it must, of necessity, deliver the result which the court intends, and that it is not appropriate to have the kind of de facto analogue, as we call it, which the Court of Appeal devised with respect. My Lords, there are 2 basic points. First of all, the executive is subject to ordinary law. That, as my Lord Hope observed in the Jackson case, is an organising principle of our Constitution. So, wealth of authority for it, Entick and Carrington onwards, of course. Jackson is at volume 7, tab 55. It's paragraph 107 of my Lord's speech.
Sorry,
755, 107.
107.
And the second basic proposition is that English law fastens on remedies. We have that in Dicey at volume 12, tab 100, page 118. There are 2 pages, just one page double-sided that is extracted. It's the second page in my lords, my ladies' bundles. And we also have it in Lord Wilberforce's speech in the Davy and Spelthorne case, and that's at volume 20, tab 184, page 276. That was the case about procedural exclusivity and the discussion of...
You dropped your voice. Which case?
I'm so sorry, my lords. Davy and Spelthorne.
Oh, yes, yes, yes.
And that's
volume... I've got the reference.
It's a procedural exclusivity case. So, my lords, from those two propositions, firstly, that the executive is subject to the ordinary law, and the importance of remedies in our legal system, it follows that the executive is subject to the ordinary jurisdiction of the court, and the jurisdiction of the court extends to parties appearing before it, a fortiori where that is the executive, and of course that is what the seminal case of M and the Home Office was all about. We've cited M at paragraph 71 of our case, the speech of Lord Templeman. It's in your bundles, the red volume. I won't take my lords, my lady to it unless my lords, lady want me to. But the reference is red volume, tab 6, and Lord Templeman at 395, B, D, F to H. Which conclusively, of course, established that injunctions lay against the executive and that the executive was subject to the coercive jurisdiction of the courts. There is also a reference to what Lord Steyne calls the ordinary role of the courts, standing between the executive and the individual, in the Jackson case again, at para 102, that's volume 7, tab 55, paragraph 102. And of course there, Lord Steyne is contemplating what might happen if a provision of primary legislation contained a clause which sought to displace the ordinary role of the courts. We're, of course, not in that situation. My lords, we say that the jurisprudence of Strasbourg is illuminating in this respect on the importance of a court being able to deliver a binding remedy. Can I take my lords, my lady, very briefly to the Van der Herk case? This is a case about milk quotas from the Netherlands. This is at volume 15, tab 122. Our case, paragraph 84.
84.
Of our printed case. But if I could take my lords to the case itself, volume 15, tab 122. So the applicant contested the quota he'd been allocated. There is a provision in Dutch law which enabled the executive to ignore the judgment of the tribunal. That's at, the provision is set out at paragraph 37, page 490. Section 74 of the Industrial Appeals Act. If, in our opinion, the consequences of a judgment are contrary to the general interest, we may, on the recommendation of those our ministers whom it concerns, decide it shall not be followed, or shall not be followed in its entirety. Section 75 provided for the payment of compensation in such a circumstance. And my lords will see at page 493, this was in the days before unicameralisation, so proceedings before the Commission in bold at 39, the applicant submitted that the board wasn't an independent tribunal because of Article 74. The fact that the provision had never been applied wasn't relevant, and its very existence constituted a threat to the board's independence. And then the court concludes at paragraph 45 at page 498. In the court's opinion, the power to give a binding decision which may not be altered by a non-judicial authority to the detriment of an individual party is inherent in the very notion of a tribunal, as is confirmed by the word dissemination. This power can also be seen as a component of the independence required by Article 6.1. And down the page, my lords, my lady, 48, paragraph 48, in the government's view, the existence of the Crown's powers under Section 74 was no obstacle to classifying the tribunal as a tribunal, since Section 74 didn't confer upon the Crown the power to overturn the tribunal's judgments as regards their reasoning, but merely the possibility of blocking their consequences if they ran counter to the general interest. In addition, Section 74 of the Act was in any event a dead letter. No use had ever been made of it. And over the page at 49, as the first argument, the court, while accepting that Section 77 may be construed as suggested, points out that for an individual litigant, it is the consequences of litigation, the operative provisions of the judgment, which are of importance. The actual contents of his civil rights and obligations is determined by those provisions. And then over the page at paragraph 54, the court notes that Section 75, this is a compensation provision, Section 75 did not allow the tribunal to depart from the Crown's decision under 74 to the extent that the possibility of retrial can be hardly be considered an effective remedy, and compensation can't be equated with the advantages obtained under an original judgment. And at 55, there was a violation. The three dissentients dissented on the issue of whether or not the applicant was a victim, not on the substance of the majority's reasoning. My lords, in this volume, the next tab, you have Chahal. I'm not going to take you to it because it's such a well-known authority. But of course, in the Chahal case, what you had domestically was the so-called three wise men procedure in national security deportation cases. The panel could not issue a binding decision. They merely gave advice to the Home Secretary, and that was not a court, and the relevant passage is at 130 at page 468. And of course, it's this judgment that led to the creation of the Special Immigration Appeals Commission. My lords, my lady, we can test, we respectfully suggest, the issue of what the court ought to do with this order by imagining if it was cast in slightly different form. Perhaps I should take you to the order very briefly. It's at volume 18, tab 150. Mr. Singh's already, of course, taken you to it. The offensive provision is, of course, 3.1b, or indeed 3.1a, as my Lord Hope noted. But imagine, my lords, my lady, if there was interposed between the listing by the Sanctions Committee and the courts here a Treasury decision. Let us suppose that there was a power in the Treasury under Article 4 not only to designate persons as is set out there, but also a power conferring either discretion or indeed an obligation to designate where the Sanctions Committee had then listed. Then, if we imagine in Article 5, which provides for court supervision in 5.4, imagine if we had, in relation to that subclass of case, where domestic designation followed on from Sanctions Committee listing, imagine in that class of case if there were an ouster clause. And there would be an ouster clause in delegated legislation vis-à-vis executive action, vis-à-vis coercive executive action. And we say it's very clear that in those circumstances the order would be struck down. And we say there's no reason whatsoever why, simply because there is no domestic decision in 3.1b cases and the order is framed as it is, that the legal position is any better for the Treasury. And, my Lords, those are my short submissions on the appeal, on Mr. Swift's appeal. As far as the cross-appeal is concerned, I need permission for that. You'll see, my Lords, from our case at paragraph 94, that those instructing me were told that we should seek permission to cross-appeal in our printed case. We say two things. Our submissions are set out on our cross-appeal at 94 to 103 of our printed case. Our first submission is very straightforward. If Mr. Singh is successful, then it would follow that we would also be successful, and it would follow that the Al-Qaeda order would fall to be quashed. We say, secondly, and this is more ambitious, but we say still orthodox as a matter of principle, if only we are correct, because somehow the court considers that a person in the position of G has had his constitutional rights of access to court and due process respected. So if my Lords, my Lady, dismiss Mr. Singh's appeal but find in my favour, then we say again, the order should be quashed and declared unlawful. And in that circumstance, my client would have been the right litigant at the right time. It would be true that G would also benefit, but we say that in order to be intra vires, the order must respect the fundamental rights of all those it potentially catches. And what happened in this case is, of course, that Mr. Justice Owen, you have this at page 1 of the appendix, declared the application of the order to be unlawful in our case. And what that has prompted is an amelioration, as the Treasury put it, in the licence conditions to which my client and his family are subject. In fact, all that's happened is that the reporting condition that was imposed on my client's wife, and there was a contest as to whether or not there was power to impose a reporting condition, all that's happened is that has been lifted, so she no longer has to report on a monthly basis. You see that from page 475 of the bundle. And they've been permitted to transfer limited funds into the wife's account as well to pay for school fees, as I understand it. That postdated Mr. Justice Owen's order, but as we understand it, the request for that antedated the proceedings before Mr. Justice Owen, or certainly his order. Maybe that the reason why that has been the response is because these proceedings were subject to appeal before the court.
That's what I was going to ask.
Indeed.
If you were to be successful,
Yes.
wouldn't the relief you've already received be adequate?
It would in ordinary circumstances, of course. The government, the executive, follow the law as declared by the courts. But we simply say, and I hope it's not inappropriate to observe, that there are difficult issues in the case, and there may be an invocation in extreme and exceptional circumstances of the obligation under Article 25 of the Charter. And we say, in order to make the position absolutely clear, it is appropriate for a quashing order to issue.
Has there been any discussion in this case, in any or any of the cases, of whether any quashing order should be immediate or should be stayed? The European Court
Yes.
took some such course, and maybe the Treasury is sufficiently armed with alternative versions that it didn't apply for anything like that.
Well, that would be a heretical course for the court to take. This was an approach canvassed in the Evans case, if my lady will remember, the idea that the courts could prospectively or declare something to be ultra vires or unlawful. And I think Lord Hobhouse said in clear terms that the constitutional role of the courts is to decide disputes between parties and to make coercive orders. The Court of Justice has a different system. It's not a system which we have at all, and it wouldn't be appropriate at all for my lords, my lady, if my lords, my lady were with either Mr. Rabinder Singh or my submissions to defer giving effect to what the court's view was on the substantive issue. And there would perhaps be issues as to compliance with Article 6, subject to the Al Jeddah point, see the Van der Herk case. Unless there's anything else, my lords, my lady, those are my submissions.
No, thank you very much.
My lords and my lady, there are 6 points that we would like to make in relation to these cases. The first involves going back to Section 1, simply to say this, that the principles that relate to Section 1 are the same as we said they were yesterday. The formulation may be very important, though, and may potentially lead to different results in the different cases. For example, in relation to transposition, we emphasised in our argument that one is looking for something clear, precise and unconditional to have a fast-track executive order implementation bypassing the democratic accountability. That's a complete answer in relation to control orders, for example. It's a complete answer, we say, in relation to the terrorism orders and the terrorism resolutions. But one can imagine very specific provision relating to specific individuals where a different answer may arise. Conversely, on the principle of legality, the formulation is vital. You'll recall the exchanges, my Lord Brand, my Lord Mance, exploring the distinction between interference on the one hand and violation on the other. And we had put before the court Lord Hoffman's formulation, which emphasised that general words in the statute don't allow the power to be exercised in such a way that would violate a fundamental right. Now, that formulation is vitally important in relation to these cases, where one has the basic rights of natural justice and of access to the court, we say most obviously being violated. One must not throw out babies with bathwater if one reaches the view that broader formulations are inappropriate. Our second point relates to what the Court of Appeal did in this case. The Court of Appeal recognised rightly and for sound reasons the need for effective judicial protection involving a merits-based review where the individual gets to know the case against them. And the case against you is not, you are listed. The case against you is not you are the person who is named in this list. The fundamental right is to know what you've done wrong. What's the basis for this restraint? The basis is that which lies at the bottom of it. And you'll see that throughout the judgment, in particular, of the Master of the Rolls, starting as he does with Cardi at paragraph 20, and then explaining the vital importance recognised before the Court of Appeal by Mr. Justice Collins of a merits-based review. That's the second point. The third point is I'd like to pick up the question my Lord Brown asked about what is needed, what would be needed for a scheme to operate which did recognise fundamental rights. And the first point, and I'm of course not inviting you to redesign subordinate legislation. Subordinate legislation that fails to guarantee natural justice is quashed. But the first thing that is needed is that the executive take responsibility for the measures that are being implemented against the individual on the domestic plane. And on this scheme, you can see what's gone wrong immediately, because there is provision for directions. And when you have a direction, you go to the court via an express protection with now a bolt-on of the procedures provided for in the 2008 Act. And the problem is that there is a category of cases where, as the scheme is formulated in the subordinate legislation, there is no direction. And it is a bizarre scheme that one has in the statutory instrument. It is bizarre for this reason. You have greater protection if you are a case of doubt, because if they reasonably suspect that you're the listed person, that's when they make the direction under the executive order. And that then leads to the express mechanism for a judicialised process in the High Court where you can apply to quash it with all the procedures that have now belatedly been enacted.
But you can only apply to quash it on limited grounds, namely that there aren't reasonable grounds for suspecting that he's Osama bin Laden.
Precisely. And that's the second thing that is most obviously wrong with this scheme. What's wrong with this scheme is the formula of reasonable suspicion. We've made submissions about reasonable suspicion, but here it is, doubt as to who you are. In relation to reasonable suspicion, I asked my learned friend Mr. Singh to mention 3 passages in the guidance that you saw. You remember that you saw guidance relating to the operation of these provisions. And the relevance of those paragraphs in the guidance is it makes crystal clear. It was page 325 in Appendix 1, I think, in G. At the level of the UN, true, this was paragraph 6C. It's not a criminal charge or conviction that's necessary for inclusion on the list. However, and this was page 328 and it was paragraph D, the mechanism it entails a state showing. You see the reference to the statement of case should provide as much detail as possible on the bases for listing, including 1, specific findings demonstrating the association or activities alleged. Nothing here about reasonable suspicion. And you've seen the resolution itself. So the point we were making yesterday would be precisely the same if the government in this country had decided to introduce a reasonable suspicion test in any way in this area. But paragraph E, which is the next subparagraph on that page 328, makes the point that the whole function of listing is to provide specific information to enable the accurate identification of the individual. It was Appendix Part 1 in G, page 325, and that was the reason why I was inviting my learned friend to show you those phrases.
And the paragraph was, my lord, it was 6D.
D at the top of 328.
Yeah.
You see, what's needed is specific findings demonstrating the association or activities alleged, and then you have to support it with evidence. And then E, that the point of the listing is to provide specificity so you can have accurate identification. Now, I repeat, and need to, in case it got lost along the way, that reasonable suspicion as a basis for provisional action is something that we accept that could be legitimate. But as I said yesterday and repeat, the first point is that it ought to be provided by Parliament. There's nothing in the resolution that's requiring the state to take action on the basis of reasonable suspicion of anything. Secondly, however, if it is going to be done, and if it could be done in an order which we don't accept, then it could only be provisional. There is absolutely no basis on which you could retain as a final control, consistently with the principle described by the Master of the Rolls at paragraph 48. If you're going to intrude on human rights without Parliament being involved, it's got to be the minimum that is necessary to do what is required of you by the express words of the resolution. The third thing that is of vital importance is to retain what the Court of Appeal recognised, and that is a merits-based review of the underlying allegations, what you are said to have done wrong. That's what would be needed to have a fair system. I am not arguing, I don't know if Mr. Swift will, that you should somehow substantially sever this instrument in order to uphold it. But I am, I hope, trying to address Lord Brown's question as to what would be needed. That's our third point. Our fourth, fifth and sixth points all relate to Cardi, because there are three alternative ways in which the Cardi case points the path forward. And it does so compellingly. The first of them is that it has the strongest analogical force. It compellingly demonstrates the approach to be taken in an autonomous legal system based on the rule of law, with the guarantee of fundamental rights and natural justice and effective judicial protection when you are reviewing a reviewable legislative instrument. That is precisely what the Grand Chamber in Luxembourg did. Autonomous because here domestic law operates on the basis that Security Council resolutions are not directly effective. It needs the role and responsibility of state authorities for Mr. Singh and Mr. Hussein's clients to be visited with these kinds of controls. And it is frankly nothing to the point that behind this is an international law duty. As Mr. Singh explained, the Suring case is a good illustration where the starting point is an international law instrument with a duty. There was a duty to extradite under the extradition instrument with the United States, an undertaking to extradite Mr. Suring. And can I just give you the reference for this reason? It's Bundle 14, tab 114. If you do get the opportunity to go back to Suring and have a look at paragraph 121, in Suring there was an Article 13 challenge saying I didn't have an effective remedy in my domestic court. The United Kingdom argued, yes, you did, because public law duties apply, even though we have an international law instrument and an obligation. Basic standards of reasonableness and fairness will operate so that you can challenge the executive in deciding to extradite you to a country where you face inhuman or degrading treatment. And that argument was accepted by the Strasbourg Court. And that's why it is right in principle that domestic law rights under domestic public law are protected autonomously based on the rule of law, notwithstanding that there is an obligation in an international instrument. As to the system based on the rule of law guaranteeing fundamental rights, natural justice and effective judicial protection, may I invite you to join the dots between paragraph 316 of Cardi in the Grand Chamber, that's bundle 13, tab 105, paragraph 316, and the two sentences encapsulating the domestic position in Lord Steyne's speech in Pearson, which you've seen. It was page 591 at letter F, bundle 4, tab 22. There is a clear and direct parallel in the position of United Kingdom law, which guarantees fundamental rights, natural justice and effective judicial protection, based as it is on the rule of law. And in response to a comment by my Lord Hope, there is also a direct parallel here with the approach that the Privy Council will take in applying constitutional natural justice based itself on English common law. One reference, the case is Chouan. It's in bundle 2 at tab 12, and you'll find Lord Diplock at page 670G explaining that it is fundamental to the concept of law as recognised in the natural justice principle in English domestic law, that law must guarantee natural justice. Now, that principle must be at least as relevant when you are considering an instrument of subordinate legislation. If the right case, the case of the blacklisted individual who couldn't work in their vocational field, had been a subordinate instrument, there would have been no difficulty at all in the House of Lords quashing it, and they wouldn't have needed the Convention, wouldn't need the Human Rights Act and declarations of incompatibility. And moreover, if the Secretary of State in Wright had said, look, the case against you is that you're listed. We have two lists, two different Secretaries of State. If you're listed for one, it automatically follows through for the other. The case against you is that's your name on that list. And so I'll give you an opportunity to respond to that. The answer would have been very straightforward, as it would be if you had action based on being on an Interpol list. The case against you is that you are the name on this list. Or if you had action being taken to restrict a product on the basis that it's what the scientific panel has recommended. The case against you is that they said we should ban it. Natural justice always requires that the underlying basis be ventilated and responded to. The fifth point is that even if that were wrong, and it isn't, Mr. Singh is right, domestic law is amply sufficient in these cases. But even if that weren't an end of it, Cardi emphatically confirms that Article 1 of the first protocol of the Convention, the European Convention on Human Rights, including its due process guarantee, is not displaced by a Security Council resolution. There is no getting around it that an essential step in the reasoning of the European Court of Justice was that Article 1 of the first protocol applies and is not eclipsed by a Security Council resolution. They didn't forget about the tiebreaker provision in the United Nations Charter, Article 103. The judgment of the court begins by describing the legal context, and at paragraph 10 you find the reference to Article 301. At paragraph 74 in Cardi...
103.
103. At paragraph 74 of Cardi, you'll find a summary of what the Court of First Instance had decided. And the Court of First Instance decision was based on Article 103. of the Charter, and in turn had informed the Court of Appeal's decision in Al Jeddah that was upheld by the House of Lords.
So what paragraph was that?
It was paragraph 10 and paragraph 74. It would be surprising if the Luxembourg court had forgotten about Article 103 when you look at who led the United Kingdom's team in that case and in Al Jeddah. If there is no eclipse of Article 1 of the first protocol viewed from Luxembourg, there is absolutely no basis to suppose there is an eclipse of that same article when viewed from Strasbourg. And indeed, you see the Luxembourg and the Strasbourg courts interchangeably considering these issues. And when yesterday we reached proportionality, Mr. Swift's first two cases cited to the court on the application of proportionality under Article 1 of the first protocol were Luxembourg cases. Now, in fact, there never was an eclipse of Article 1 of the first protocol, and you only need to read Bosphorus, which we describe in paragraph 21.3 and paragraph 60 of our printed case, to see that that is so. The reasoning in Bosphorus, which was the case of the aircraft which had been impounded under an obligation which had emanated from a Security Council resolution, it is entirely inconsistent and would have been much, much shorter if Article 1 of the first protocol were to be read as though it began with the words, save where acting under a Security Council obligation. What the Strasbourg court in Bosphorus did was that they recognised that the Security Council resolution could have a role in relation to whether the legality component of Article 1 of the first protocol was met. So if you're going to interfere with property, the first thing is it has to be lawful. Well, it could be lawful if you've got a Security Council resolution, providing the Security Council resolution has been domesticated. I mean, that alone is inconsistent with any suggestion that Article 1 of the first protocol has already been, in some sense, eclipsed. That passage in Bosphorus is, in fact, earlier than the ones that you were taken to by my learned friend, Mr. Singh, and if I can just give you the reference to it, it's paragraph 145 on page 42. It's the penultimate subparagraph of that paragraph, and Bosphorus you have seen in bundle 16 at tab 130. So they discuss, is this lawful, this interference, by reference to the Security Council resolution because it's binding and because it's been domesticated. When you then reach the overall questions of proportionality and fair balance, you find the answer to my Lord Mansis question from yesterday about faith in an international organisation. Strasbourg has articulated the principle which is applicable, where you join up to an international organisation that then imposes obligations. And it is entirely consistent with the Cardi approach. You can presumptively say, well, you would expect there to be compliance with fundamental rights, providing there is a system of equivalent protection. But even that is only a rebuttable presumption. That principled approach is entirely of a piece with what we later see in Cardi, and with the greatest of respect, is inconsistent with any suggestion that there is an eclipse of Article 1 of the first protocol, whether or not there is a justification for reading words into Article 5, paragraph 1. If you want, I can say more about Waite and Suring and Bosphorus and Matthews, but I think the point has been adequately dealt with. I would like to record that the effective protection principle derives from an intervention in Al Jeddah by Justice and those there acting on its behalf. It's page 336 at letter C. You'll see that in the argument in Al Jeddah. My final point, I say that because it wasn't me acting in that capacity in that case. The final point also relates to Cardi, and we did fairly and squarely raise this. There's no rabbit out of a hat. On the 14th of September, we lodged a printed case, and paragraph 59 takes the EU point, and it's a very simple point. If we got this far, Mr. Swift would have sought to deflect common law and to deflect Article 1 of the First Protocol, only to find that in Cardi we have the binding articulation of imperative community principles, and they are applicable to United Kingdom acts within the sphere of EU competence. The competence can readily be seen from paragraph 35 of Cardi in the Grand Chamber, because the EU, under its relevant treaty provisions, the Common and Foreign Security Policy, had enacted an instrument deciding that these Security Council resolutions were to be implemented in the community. It fell within its competence, and it had acted. That common position you will find in the red bundle at tab 12, and behind it you will find Article 15, on which it is based. The position, the logic of the position explained by the Advocate General at paragraph 30 is we submit unanswerable, and it would be bizarre to test the position. It would be bizarre if, for example, we'd had a directive rather than a regulation. If we'd had a directive calling on member states to act in the context of these Security Council resolutions, for the United Kingdom to say, well, if we choose to say we're acting under community law, there will be one standard of fairness for the individual because general principles of community law will apply, see Cardi, but that all of that is avoided where we have a context where the community has acted, but we choose to say that we're doing it off our own bat. We say that is the principled and logical position. It doesn't arise because we don't get to this position. In fact, we don't even get to the Convention, because the constitutional protection of natural justice explained by Lord Steyn in Pearson is amply sufficient to guarantee the due process rights which arise in this case. Finally, my Lord,
as a matter of interest, though, how far does the argument go? The community competence to pass the regulation was discussed. Am I right that it was largely or exclusively under Article 308 of the European Communities Treaty?
The Grand Chamber exhaustively considered the competence and upheld the legality, the vires of the instrument.
No, I was talking about Cardi. In Cardi, it's Article 308, which provided the varies. Where the community has competence, are you suggesting that individual countries can't legislate?
No, I'm saying that the acts of the member states are accountable through EU law to the general principles of the community. We've got textbook authority for it in the bundles.
I mean, this must be an argument, therefore, that the community competence isn't exclusive. It doesn't exclude national member states legislating, but nonetheless, if they legislate, they are bound by the community approach, which is rather circular, an odd argument.
My Lord, I wouldn't accept that it's circular at all. What it requires, what it involves, is that general principles which are applicable through EU law follow through, as one would expect.
It's the principle of loyalty, then, is it the Advocate General's principle that if you legislate, if you retain competence and legislate, nonetheless you have to do so in the same way or consistently with the way in which the community has done it?
All it is doing, and it's a measured principle, but it's one which has an important and fundamental grounding, is that it is holding you to those same basic guaranteed values that represent the general principles of community law. And so that's the prize for escaping the common law or Article 1 of the First Protocol, which we say is impossible in any event. Finally, may I say this, that no written intervention can anticipate what is said, asked or shown, and as always, therefore, Justice is very appreciative of the Court for allowing permission to extend to us being here. Those are our submissions.
Could you put your microphone on? Thank you very much.
Sorry. Could I first respond
What worries me is that actually switching it on has awfully little impact. I don't know. Why, certainly it seems to have awfully little impact by the time it gets to this part of the course.
I'll try just to keep my voice up then. Could I first respond to the question put by my Lord Brown yesterday afternoon in relation to the terrorism order, which was a query as to why that order had been made as an order rather than by way of primary legislation. And also this addresses the point raised with me by my Lady Baroness Hale as well, to similar effect. The position is the answer is straightforward. The view taken was that the power under Section 1 of the 1946 Act provided the power to give effect to Resolution 1373 in English law. And so on that basis, there was an existing basis in primary legislation under which the provision could be made. And in such circumstances where there is already an existing provision in primary legislation that provides the power to do something, it is not normal practice to seek further primary legislation in respect of that matter. So, my Lord, I suggest that answers both your query and also perhaps answers my Lady Baroness Hale's query. The powers were used simply because the view was taken that by reference to the Security Council obligations in question, Section 1 was an adequate basis for legislating, an adequate power within primary legislation.
That puzzles me a bit. It follows that all the primary legislation dealing with terrorism was passed in the view that they couldn't use.
Yes, but yes, my Lord, perhaps I'm speculating here, but perhaps by reason of the considerations I suggested yesterday, that when one has, for example, a call to criminalise certain conduct, the view taken was that simply the degree of connection between the Security Council decision and the existence of the power under Section, or rather the power under Section 1 of the Act was such that it would be preferable to use primary legislation to put that into effect.
But if you were to accept your proposition, the one you just made a moment ago, it would rather seem to be an invitation for you to do more of this sort of thing. I mean, the scope is very general, and the way would be open to you to do it. Are you accepting that there would be any kind of restriction on the use of it, apart from what you just said, the degree of connection between the measure taken and the resolution?
Well, what I do say is, going back to the point I attempted to make yesterday, that one has to consider each situation in its circumstances. Hence, I was loath to be drawn yesterday on speculative situations, and I remain of that position today. The submission that obviously I do make in relation to the terrorism order is that looking at the provisions of paragraph 1C and D of 1373, there can be no argument but that those provisions could be implemented by the Section 1 power. Different cases will need to be considered on their own circumstances. And I would suggest that given the purpose of the Section 1 power...
This comes very close to accepting the speculation that I put to you. That because the connection was so obvious in relation to the directly listed people and the Al-Qaeda order,
Yes.
The decision was taken, well, we'll go on doing this freezing bit by the same mechanism.
Well, I wouldn't, with respect, formulate it in precisely the same way. The approach, the question was, or the matter addressed was, is the power under Section 1 available to allow effect to be given to paragraphs 1C and D of Resolution 1373? The answer to that question, right or wrong, but the answer to that question was yes, it is. And on that basis, the existing power in primary legislation was used instead of seeking further primary legislation to give effect to 1373.
There was already primary legislation in the form of the Anti-Terrorism, Crime and Security Act 2001, wasn't there? And without going through every bit of it in detail, one would have thought that the first question would have been, have we not already got in place a carefully thought out bit of primary legislation which covers the whole of this field.
Well, my Lord, as I said yesterday, the 2001 Act, the provisions of it that you've been taken to, do not cover the same ground. They are more limited. They are dealing with different matters. That legislation, I think, was made in either late November or early December 2001, I think.
Yes, it received the royal assent on the 14th of December 2001, yes. So it was enacted very quickly, yes.
Yes, and I'm afraid I don't know, standing before you, when the bill was first introduced, but it would have been towards the latter part of 2001, obviously. But by when,
in fact, the terrorism order had already been passed in its original form, October 2001.
But my direct answer to your question is simply that the provisions in the 2001 Act are not doing the same thing. They are directed towards different matters. Those are the submissions I made yesterday on that point.
And I'm sorry, the control order regime, I thought your position yesterday was that it could have been, although it wasn't thought appropriate to deal with it, under the Section 1 power. But
no, my Lord, what I said yesterday, firstly, I didn't want to be drawn on that. Because
no, I know you didn't want to be drawn into it, but given that you are drawn into it, I mean, could it or couldn't it?
My Lord, in short, it's an entirely speculative issue. If the control order, a control order procedure had been introduced on that basis, as I said yesterday, no doubt there would be intense argument as to whether or not there was a proper basis in Section 1 for introducing that sort of regime. But that's the long and the short of it. There would be a legal argument on that. It's not necessary for you to decide this case to know whether or not a control order regime could have been brought in by reliance on, for example, Resolution 1373 or any other resolution and Section 1 of the 1946 Act. It's simply unnecessary to think about it. As I say, I apologise, it appears to be a rather mundane approach, but I do urge you to focus on the particular measure that has been made and the simple question of whether that measure falls within the enabling power. Of course, as Mr. Owen's submissions as to the possible ways in which Section 1 could be read down are submissions to be considered. But as we submitted yesterday, those suggestions find no foundation anywhere within Section 1 itself. And on that basis, his suggestions are not an act of construction, they're an act of legislation. Sorry, well, there's one other point I wanted to make in relation to the 2009 terrorism order, which is a matter I should have mentioned yesterday, a factual matter, just to bring the court up to date on the facts. Mr. Owen very fairly made the point that although the 2009 order is in force, his clients remain subject to the provisions of the 2006 order. That is correct. For the moment, the appellants remain subject to directions under the 2006 order. But that is pending consideration of whether new directions should be made in respect of them under Article 4 of the 2009 order. Those decisions will entail reconsideration of all available material. That consideration is already underway, and it is expected, it is anticipated that decisions will be taken as to whether or not directions should be made under the 2009 order by the end of this month. Now, if the decision is that a direction should be made in respect of any of the appellants under the 2009 order, the 2006 order direction will be revoked.
Will the court be informed about this? I mean, I don't know when our judgment will come out, but no, it would be helpful if we were up to date on that.
My Lord, we certainly will, yes. And so I also make clear that if the decision is that on consideration of the material available, no direction should be made under the 2009 order, at the same time, the present directions under the 2006 order will be revoked. And so the process of considering whether or not the 2009 order should apply is a process that is presently in progress. My Lords, I was going to turn now to Mr. Singh's submissions. I'm conscious of the time and whether you're prepared, willing or able to sit late this evening, or whether you've heard enough from us for today.
I think we've had a good day and we'll adjourn now.